Hi, friends. My name is Alena Shautsova. Tonight, 7 o'clock p.m., Friday, we're having our live, as promised, with regard to the most interesting changes in immigration law that we should know about. So, thank you very much to everyone who's going to join. Thank you very much who's going to be watching us after we record this. We're live on YouTube, Facebook, and TikTok. So please join and ask your questions. Don't forget to type up your questions and let me know where you're watching from, and let me know what questions of the United States immigration laws you would like to discuss today. Whenever I can, whenever I know the answer, or at least I think I know the answer, I will direct you to the point where you can start your research, where you will be able to at least get an idea as to where to start and what's happening. Many of you are very actively always participating, and I'm very grateful to you for that. I'm sure you appreciate free tip as well. So please don't forget to send your hearts and your stars. I really do appreciate all of your help, all of your attention, all of your encouragement to promote this live. Don't forget to like and share this live so more people will be able to join and get help in these uneasy times for everybody. And let's start. So this past Tuesday, we discussed certain changes in the United States immigration laws, and you can play back if you're watching on YouTube or Facebook that video, what exactly I spoke about. And today we're going to focus on new things. For example, parole for Ukrainians is a very hot topic. We have several tens of thousands of Ukrainians who were able to enter the United States using United for Ukraine program. Many of them were able to jump to TPS, temporary protected status, when it was first announced and then when it was renewed, but some were not able to. And for those who were not able to, this opportunity to file for extension of the parole is a very valuable opportunity. Especially it's true for those who came on U4U but are not Ukrainians. You may say, how did this happen? Well, because U4U allowed Ukrainians and members of their families to come to the United States. And sometimes members of the families were not from Ukraine. That's how it happened. And those people basically were stuck worrying about what's going to happen to their status when U4U is expiring. Well, if you don't have any other options, if you cannot file for adjustment of status, if you cannot file for something else, you cannot file for asylum, extension of the U4U is a great opportunity for you. Okay, you do have to file for it before the expiration of your current status, preferably within 60 days of the expiration. You will have to pay fees. You will also be able to file for employment authorization. All the requirements are very thoroughly listed on USCIS.gov website. If you're going to be handling this process by yourself, you need to know that you can file for the extension online, or you can file for the extension by mail. It's your choice. If you do not have the required fees, you will be able to ask for the fee waiver. I do have to warn you that when you ask for the fee waiver, sometimes your application is erroneously rejected. So if you can get the money together, just do it to avoid the rejections. But again, it's up to you. I understand that there are circumstances where you will be hesitant to, or you just don't have the money to file, to supply those government fees. One more thing to know is, of course, again, a reminder about USCIS fees to go up on April 1st. This is like the 5th time I'm reminding everybody about that. It's very, very important that you remember it. It's imprinted by now in your memory that you have to hurry up if you have some applications to file. Of course, there may be circumstances where you need to take your time, right? Because some cases are more complex than others. Maybe you're working on an EB2 national interest waiver case, EB1 case, and you have to have that time to translate everything and to put everything in order. And hurrying, saving a couple of $100s in a grand thing of events, it's not worth it. You'd rather do a very good application rather than save a little bit of money on a filing fee. Remember that. But if there is no difference for you when to file without compromising the quality of your filing, file earlier than later. That's how, generally speaking, it works. All right. So these are the two important announcements I wanted to speak about. And now, if you guys have some questions, and don't forget to like and share these videos. Don't forget to send me stars and hearts. Let's start. We're going to jump right to your guys' questions. So hello, Facebook and YouTube. We're going to start with you guys. Hi, Makan. How to check PD request? The only way to do that would be to follow up with the APLA Office of Principal Legal Advisor's Office to see where you guys are standing with the request. That's the only way to do that. Hi, Samantha from Brooklyn. Yay. Hi, Ben Manx. When can SIJ apply for work permit? Generally speaking, after the SIJ petition is approved. All right. Hi, Adventure TV USA. Hi. I'm from the Bronx. I'm a parent of 9 years old US citizen. Can I get work permit and social security through my child? And I want to know about 10 years by the petition, maybe. All right. So, guys, you need to know that just because you have a child in the United States who's a US citizen, by itself, it does not provide you with any opportunity to file for your status, legal status in the United States, unless the child is 21 years old already and they can petition for you, or you end up in removal proceedings. And in addition to having such a child who is a minor, you also can show that that child is going to suffer exceptional or unusual hardship in case of your removal, and you're a person of good moral character, and you accumulated in the United States 10 years of presence. But these 10 years are calculated very funny. It's not physical 10 years necessarily, it's legal 10 years. Certain events, such as service of proper notice to appear or commission of a certain criminal act, may stop the accumulation of these 10 years in the United States. You have to be in court, you have to meet all these qualifications, and then you can file for something called cancellation of removal. But even if all these points are met, cancellation of removal is a discretionary relief. The judge in the end is going to decide whether or not they would give it to you. Another important fact to remember that currently, even if the judge grants it to you or says, well, I'm thinking I'm going to give it to you, right? This cancellation of removal approval. It's going to take you another 3.5 years before you're going to see your green card. So this process is a very long process and very serious one. What happens in court? Well, in court, you can win, you can also lose. Just remember that, you can also lose. So these are the situations when one can benefit from having a child in the United States in connection with their status. There are other very limited situations. Usually they involved victims of a crime. God forbid the child became a victim of a crime. Even if the child is a US citizen, parent very often may file for a U visa. You have to know about this. Again, God forbid something negative happens in your family, consult with an attorney. Attorney will be able to see if you will be able, first of all, to remedy the situation, and of course, to maybe apply for any immigration benefits in connection with any negative events. I'm talking about you or your family members becoming victims of crime in the United States. Okay, so that's how it works. That's how it works. Hi, Hamid. Unfortunately, I do not speak French, and it seems you are sending messages in French. Hi, True Wisdom. Hi, Alena. Good to see you. I'm so excited I got my approval. I'm at the National Visa Center stage, but I cannot figure out how to calculate the income requirement. We're a family of 4, both parents. Well, first of all, congratulations. So what you need to do when you are trying to figure out how much income your sponsor has to have, you have to refer to the table that it is found in the form I-864P. I-864P. Depending on where you reside, I hope you're not in Alaska, because people in Alaska and I believe Hawaii, for some reason, have to make more money. So if you're residing far away from New York or Washington, D.C., you have to make more money, right? But what happens is this: there is this table depending on where you reside, and if you're in the military, it shows how much money, according to the poverty guidelines, the sponsor has to make. Key here is to calculate the household side correctly and also know that this money typically must be made on W-2, not 1099. Huge difference, okay? Huge difference for Department of State and for USCIS. All right, so how do you calculate the household side? There are very thorough instructions attached to the form I-864. You take family members, which typically would be parents, children. Now, to that, you add an immigrant else ever and filed an affidavit of support for them, and that someone else is not a US citizen or did not abandon their immigration, green card, immigration status. That person also has to be counted in this household side calculation. And some other people who are dependents. Maybe somebody is supporting a relative and claiming them on taxes, something like that. That's how you calculate the household side. And then you refer to the table and see how much money your sponsor has to make. What if it's not enough? Then you will have to have a joint sponsor. All right, you'll have to have a joint sponsor. Interestingly enough, the joint sponsor has to qualify independently according to this table. In other words, you cannot take income from your petitioner and from the joint sponsor and plus it, add it together. That's not how it works. The joint sponsor has to meet these requirements independently. So the whole process has to be started for them as well, just as if it was for the petitioner. That's how you do it. All right, now we're going to take a couple of questions from my TikTok fans. Hi, TikTok. How are you guys doing? My TikTok fans, by the way, are very, very active. They always send me so many hearts, guys. So those who are watching on Facebook, I know that YouTube doesn't have the same. Please send hearts and send stars. I do appreciate them, and I take your key to your questions first. All right. Hi. Thank you, guys. Thank you very much for your hearts. Hi, Hamsa. What if the case is dismissed? If the case is dismissed in immigration court, it means that there is no active case pending. You are no longer in removal proceedings, but it also means that any application that was pending in immigration court is now closed. And if you were relying on an employment authorization based on that pending application, now you will no longer be able to extend that work permit. Okay, so when you are agreeing to the prosecutorial discretion, you need to understand the choice between administrative closure and dismissal. And I have an excellent video about that on my YouTube channel. Hi, Fury Shark. I want to be a guest, please. You know, it's interesting that you ask about that, because right now I don't have any guests, but I am discussing with someone about having guests over. I just need to figure out the logistics. So whoever wants to be a guest, please email me. Tell me a little bit about yourself and what is it that you would like to talk about. Just a couple of sentences. You can email me at office, just like an office, OFFICE, at Shautsova.com. Okay, and we're going to figure out how we can invite guests on various platforms and do a little bit collaboration where you will be able to share your story, and we will be able to, have some discussion. Now, remember, guys, when you are appearing as a guest, showing your face online, whatever information you're sharing becomes public. okay? It becomes public. It's very important that you know that not only us, people who are in this live situation, may see it, government may see it as well. So please do not share private information. Do not confess. Do not confess on anything on my lives, please, okay, please. For that particular reason, I also never do what's called, some lawyers referring to, group consultations, where they collect money from 5, 6, 10 people and say, oh, it's cheaper for you. You're going to be as a group asking questions. But then it becomes like a paid chat more than a consultation, because confidentiality aspect of your consultation now is lost. When you consult with a lawyer one-on-one, an attorney cannot share with the world or government or whoever is asking about the aspects of your questions and answers. But when the discussion is public, confidentiality is lost. Remember that. Oh, somebody listened to me and called himself user 51 something something. If my criminal charges get dismissed and expunged, can I apply for citizenship? I do not know. Why? Because what happens is this, believe it or not, but the United States immigration laws do not recognize expungement as full clearance of your criminal charges. You still have to mention that you were charged with something on the N400 form and attach certificates of dispositions that you were charged with a crime, and you still have to mention the result. However, if your case was dismissed, you may still be asked to explain as to what happened. If in your explanation, the officer is going to hear confession to commission of a crime or criminal act, this may be held against you regardless of the fact that your criminal record in a criminal court was dismissed and cleared up. Just know that whenever we're dealing with the criminal acts, you have to be very careful. You have to consult with an attorney. Dismissal by itself may not be enough to clear up the path to your citizenship. Usually it is, but it may not be enough. Another important factor to remember is that recently, Board of Immigration Appeals rendered a decision in a case that dealt with motion to reopen and vacation of the previous conviction. And Board of Immigration Appeals stated that if the judge's order in a criminal case and the record does not contain evidence that the criminal conviction, criminal charges criminal case was reopened and charges dismissed because of the substantial or procedural defect, such a dismissal will not be counted vacatur, will not be counted for immigration purposes. So criminal immigration law is extremely complex and not as forward as you may think. Just work with an attorney, okay? All right, I want to move to the United States. It's not so easy. Whoever wants to move to the United States, you need to know that it's not an easy path. Long-term immigrants or even immigrants who are in the United States for a couple of months will all share with you that United States is not the easiest country to move into, especially right now. Hi, Bilak, I'm on B1, and I apologize. I apologize if I mispronounce your names. I'm on B1, B2 visa in New York. What I need to do to change, I assume, status? All right, guys, when you enter the United States on a tourist visa, which is very popular, relatively easy visa to receive, the presumption is that you're coming as a visitor. You're going to spend some time and you're going to go home. However, situations happen and some people change their mind and try to look for opportunities to stay in the United States. Most commonly, they're going to, whenever it is applicable, use these three routes. Number one, they will try to extend their tourist status. It's possible to do it in the United States. Typically, when you come into the United States on a B1, B2 visa, you will be given 6 months to stay. By the end of your legal time here, you will have to file for the extension. Okay? Some people are going to change status to F1 status, student status. For that, you will have to have school that's going to be able to admit you as a foreign student, very important, and issue to you Form I-20. And of course, is going to meet some other requirements for the international student program. And it's possible to do that. Remember, it is up to USCIS to approve your request to extend or change your non-immigrant status. Yet another popular opportunity is for those who are eligible, to try to go from B1 status to E2, non-immigrant investors. Some people will get married and get green cards based on marriage, but most employment opportunities will be foreclosed for those who are coming to the United States on B1, B2 visa, just because the way the process works, apart perhaps from maybe EB1 extraordinary ability visa, technically employment self-petitioning visa. So those are about the most popular ways. Which one may work for you, I do not know. I provide here just general information sufficient for you to start your research, right? That's what we're doing here. Hi, caller Dan. I got I-90 denial. I wanted to replace my card because a hyphen was missing from my name. What happened? Why did you get the denial? Give me more information. I'm interested now. What happened? Hi, Alex. What kind of proofs can I take to the family court for special immigrant juvenile status? It depends on why you're filing for it. What are you arguing? To win case in family court, you will have to the satisfaction of the family court judge, prove that you were abandoned, neglected, or abused by one or both parents. What can you show? Was it something related to, let's say, the fact that your father typically was not listed on your birth certificate and never cared about you? Maybe there was a court order from your home country that your father did not pay the child support, abandoned you. Maybe something like that. Medical records showing, God forbid, evidence of abuse. Maybe none of that. And it will be only your testimony. Okay? Sometimes it's possible to win the case if the judge believes you just on your testimony. And remember, there are also other requirements in family court. And after you pass family court stage, you will be filing for such petition already with immigration authorities. Immigration authorities are going to look at your previous immigration history. So just keep it in mind, okay? If you tell one story on your visa application, and then you go to family court and tell their different story about your parents, and then you file for I-360 petition and tell yet another story, you're gonna get yourself into trouble. So make sure that you are truthful all the time. Thank you guys for your stars and hearts. Don't forget to like and share this video so it will be more popular and we're going to have more people joining us. Let me see if we have more questions on TikTok. All right. Hi, Sayed. Can I get green card to get married with USA citizen who taking benefits Section 8 and health and some health insurance? Yes, sure. You can get married to a US citizen who is relying on government benefits, but you will need to have a joint sponsor for your green card. Just keep that in mind. Hi, Veronica. After first interview for I-45, USCIS sent another interview. Why? Was your case or is your case based on I-130 filing? So if that's the case, typically USCIS did not believe that your marriage was real and they would like to interview you guys again. But if your case is based on something else, it's very rare that you're going to have another interview. And you can share with me some more details. So maybe I can give you some better tip on how to approach the situation. But I'm going to tell you that if you're called for the interview second time, if you can afford it, get yourself an attorney. Something is cooking, right? Something is happening. Hi, Kojo. I'm going to take some questions now from my YouTube subscribers, right? You guys are subscribers. Hi, Kojo. Can I adjust my status through my US citizen brothers? That's a good question. Many of you have family members in the United States, wondering if those family members can help you out. Well, US citizen brother or sister can file petition for you, I-130, that will serve, when approved, as basis for your green card application or immigration visa in the future. Usually, you will not be able to use this petition in the United States because the law for that particular category of relationship requires you to demonstrate that since the time you entered the United States until the time you can use the petition, which is going to take 10 to 15 years typically, you maintained lawful non-immigrant status. It happens very rarely that you'll be able to demonstrate it, or you will have to qualify for some narrow exceptions. So while your brother should initiate the process, you have to know that to finish up the process, most likely you will have to get at least I-601A waiver, and you will have to be able to qualify for it. Thank you very much, MD, for the rose. Thank you. Hi, Omar. How long does the I-360 takes to get approved for SITch? 180 days. It should take no more than that under the current law. It should take no more than that. Hi, Andy. Hi, Alena. I am a U visa applicant. My mom's sick and I have to go to Turkey to see her. I know I'm not able to come back till my case approved. If they're approved, am I able to come back here? All I can tell you is this. I've never dealt with this situation, okay, in my practice. Never had a situation where a U visa applicant would abandon their case and go to the home country. But what I know that it's possible, unlike for SITch case, it's possible to receive a visa, U visa at a US consulate. So what I would do if I were you, in the worst case scenario, you will have to file for that U visa petition from overseas if it's considered abandoned. But I believe that what's going to happen is that you will be able to wait for its decision in your home country, and it may take 7 years, all right? And once it's approved, you will have to file for the U visa. I believe that's the likely case scenario. Now, I honestly tell you, never dealt with this situation, so I do not know for sure how it should be played out. If somebody who dealt with it and who's watching this can share some wisdom, please let me know, but I think that would be the case. Hi, Patloreshema. Thanks for answer. After the case dismissed, can I file again to USCIS or marriage is fine? It depends on what is it that you're going to be filing for, what was pending for you, and why the case was dismissed, right? Marriage is fine. I mean, you need to know that marriage to US citizen by itself does not give you any status. It is only one of the requirements to have a legal marriage that you need to meet in order to file for the green card later. Just remember this, all right? So typically, if the case is dismissed in court, you should be able to file your case with USCIS. All right, that's how it works. Should be able to, unless you entered the country without inspection, then you are not adjustable. Maybe then you should look into I-601A waiver route. Hi, Jules Carillon. How are you doing? I'm a PD is pending over a year and 6 months. New York field office, is it normal? I have an alt removal married to a US citizen. Not normal. I'm going to give you a quick answer. No. A year and 6 months, typically not normal. Takes a little bit too long. Too long. All right. Hi, Natalia. Do you help with a marriage visa? Thank you. Yes, we do. Yes, we do. We handle all types of immigration issues, and some of them, trust me, guys, you never heard about. Sometimes we have a very interesting cases, and I love those cases because though they're interesting cases, but we also handle typical cases: adjustment of status, removal defense, asylum, immigration waivers, employment-based categories, employment visa, EB1, EB2 national interest waivers. Those are very popular because you can file for yourself. You do not have to have an employer if you qualify. And let's say we help people who are talented, athletes, researchers, entrepreneurs. You don't have to be necessarily a famous athlete or a movie star to file for EB1. You can be a very talented business person and you can file EB1 one case for yourself, showing that you're going to help the United States with your managerial talents. It's not for everyone to run a business. So the United States government does appreciate it. Hi, Natalia. To book a consultation, you may call our office, typically from 10 o'clock in the morning until 6 p.m. during the business hours, work days, usually Monday, Friday. Sometimes we're open on Saturday, but Monday, Friday. And my secretaries will work you through the process, or you can book it online, even easier. Website, shautsova.com, and there is a little field there, book a consultation. So fully automatic. Hi, Yasir. What the qualifications of immigration officers? Are they lawyers to decide? No, they're not. That's the interesting part. They do not have to have a law degree, even though I think some supervisors may have. They may have the law degree. They don't, but they do have to have training. All right, they have to have training. Sometimes extensive training if they're officers of how they call it, second level supervisors, and they have experience. But unfortunately or fortunately, they're not attorneys. So when you're filing a case, especially if you're doing by yourself, sometimes online you can find something called training lessons for USCIS personnel. And there you can get a lot of information about how they're considering cases. Extremely useful materials. Hi, Mrs. Maggie. I'm a US citizen. My husband crossed illegally 4 times. We now live in MX for 8 years. Do we wait for 10 years? Mexico. Okay. I think so. You will have to wait for 10 years. Well, the thing is this. You could start the process now if you haven't filed I-130, because it's going to take some time for that I-130 to be approved. But I would suggest that you guys talk with an attorney. Of course, it seems that your spouse would be subject to permanent bar unless some exceptions apply. And for some people, there will be some exceptions. Maybe they crossed the border 4 times before the age of 18. Maybe something else happened. They did not accumulate unlawful presence. If removal orders were involved, it is extremely important to have that information. How is it that happened that the person was crossing back and forth? Why? So please consult with an attorney. But the first thing that you need to do is to order your spouse's FOIA, Freedom of Information Act request files from USCIS and EOIR, Immigration Court and USCIS. Then consult with an attorney. If any criminal charges were at play at any point in time, also please get certificates of dispositions for every time a person was arrested. All right. Let me see. Hi, Ricky Mutebi. RFE was sent, interview waived. What is next? I do not know. I guess next would be decision by USCIS. Sometimes before making a decision, RFE, request for more evidence, comes. Sometimes two, sometimes something else comes that you don't really want to get. It's called notice of intent to deny. So offices have various tools they can use, even if they wait the interview, to make sure that the record is fully developed, meaning that they received all answers to their questions. All right. So I cannot really tell you what exactly is going to happen in your particular case. Hopefully everything will be fine and you're simply going to get your approval. Hi, Mukes Patel, how long does it take to get I-765 C14 card? I really do not know. Why? Because it depends. Sometimes people get them very fast and sometimes you have to wait for several months. All I can tell you is this. Processing times for various work permits are available on USCIS website. The fastest way to receive a work permit is through asylum. Well, how is it fast? You do have to wait for 150 days before you file for it. But then once you file for the initial work permit, it's going to take you only 35-40 days before USCIS is going to send you the work permit. And I'm going to take the last question for today. And hopefully we're going to meet next Tuesday, guys. I'm going to tell you right now that next Friday I'll be busy and I will not be able to have this live. I have a different engagement, but I should be able to do next live next Tuesday. So if your question was not answered today, please join me next Tuesday, same time, 7 o'clock, and we're going to talk about your immigration issues again. And if you need something more serious, if you need a lawyer to look at your situation in depth, if you have a more complicated question, if you need records to be reviewed or something like that, or take over the case, let us know too. We can do that, but that would be a consultation. Hi, Tony. Can I expedite my I-45 to attend my husband's graduation? Can you expedite your I-45 to attend your husband's graduation? Something interesting is happening here. I-45 is filed in the United States. Are you stating that your husband is overseas? Then how did you file your I-45? Based on what? If I understood you correctly, you always can request that your I-45 is like any other form, is expedited, always. USCIS will decide whether or not you have a good reason and whether or not they're going to approve your request. Okay, that's how it works. But one thing you need to know, you cannot expedite your line in the preference category. In other words, if you filed your I-45 based on a petition by your parent, for example, and USCIS allows you to file a little bit earlier than final action dates are available for your particular preference category, you will not be able to expedite that. Just you need to know that. All right. Well, guys, thank you very much for joining. Thank you very much for sharing. Thank you very much for sending hearts and stars. I do appreciate your attention, your participation. I hope you like this video as well. If so, please don't forget to hit that like button and share. And don't forget to subscribe to my channels follow on Facebook, on TikTok, and I hope to see you soon.